All right, before we get started, keep in mind that this account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many people, I suspect, who are worried about their immigration situation, but are not sure if they should speak with an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think your situation is nearly identical to the one I'm going to analyze here, you should still reach out to an immigration attorney. Even the smallest factual differences can change everything. That said, this is not legal advice. I'm hoping to merely educate people, as I know that a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change significantly over the next few months. They already have to some extent. So what might be accurate at the time of recording could be outdated in the next few weeks or even tomorrow. This couple married in 2018 and filed for a marriage-based green card shortly thereafter. The husband is a U.S. citizen and the wife was not. The green card for the wife was approved and she obtained conditional residence status. 2 years later, the couple filed the I-751 together. A few months later, the couple began to have problems and separated. The wife comes to me asking how to handle the situation. Okay, so they filed the I-751, which is the application to remove conditions on residency. They filed that jointly, all right? So they were together when they filed it, but now they're separated. So technically, you don't need to advise USCIS that you have separated until there's actually a divorce filed. That might be debatable, but definitely if the divorce is finalized. Okay, so there's a lot of moving parts here, but an I-751 can take a very long time to adjudicate. Sometimes we get them approved in 6 months or 9 months, but that's not normally the case. Normally they stay pending for well over a year. So if they decide that they're going to file for divorce and they're ultimately scheduled for an interview, we would need to go into that interview and advise the USCIS officer of what's going on. We separated, we filed for divorce. That divorce is currently pending. There's a few ways that the officer can handle it, okay? So we could ask the officer to put the case on hold, essentially, and wait until the divorce is finalized. And then we can change the filing from a joint filing to a good faith marriage, but ending in termination. Okay, so when you look at an I-751, there are several boxes that you can check. One is filing jointly together. That's what the majority of people are doing. But you can also check the box that says that essentially we did enter the marriage in good faith, it did not work out, and we are now divorced. Okay, so that's the second box. The third box would be we entered the marriage in good faith, but I am a victim of domestic violence, okay? And the fourth one is it would cause extreme hardship if you don't approve this removal of conditions. Okay, so those are the four potential boxes, but you can't check that second box, the entered into the marriage in good faith, but it was terminated. You can't check that second box unless the divorce is final. So if you're caught in the middle there where you've filed a divorce, so you're not still together, but you've filed the divorce, but it's not finalized yet, there really is no box for you. Okay, so in this situation, it's in terms of how to handle it, it's really going to kind of depend on, are they filing for divorce? Are they just separated for now and maybe they're going to try and work it out? They just need some time to cool off. There's so many different ways that this can go. But if someone files for the divorce or if the divorce is terminated, then we're going to have to take action, okay? Because what you really don't want is to have the marriage terminated officially, the divorce finalized, and now you still haven't gotten your green card, but then it gets approved after that. That would be a problem because years later, if you decide to naturalize, they're going to see you were divorced on this day and your permanent green card was approved on this day, and you had no right to have that approved on that basis. So there's going to be some work to do here, but it's really going to depend on the facts. Hopefully that clarifies some things. I know there was a lot of moving parts, but if you have any questions, reach out to us, give us a call, schedule a consultation, and we can go over your specific situation. Thanks.